Good morning, Council. Welcome to the First District Court of Appeals. The first case being argued today is in re MB. Ms. Moss, how much time would you like for rebuttal?
2 minutes, Your Honor.
Okay, you may proceed when you're ready.
Good morning, Your Honors. Ms. Chair, may it please the court. My name is Jessica Moss and I represent the appellant RB in this matter. This case concerns a charge of obstruction of official business based on the officers doing exactly what they were called to do. As to the first assignment of error, the juvenile court improperly deferred to the magistrate's factual findings without determining whether or not the magistrate properly determined those facts. So when the judge is required to look at whether they properly determined the facts and determine the law, it's determining the facts that was missing here. And so in this case, it's not enough that in the judicial entry, it said that the judge was conducting an independent review. You can't base some decision about the law if you don't know whether those facts are correct. And so that's where the first assignment of error, what it concerns. If there are no other questions.
Well, let me ask you just one question about that. I mean, I have some sympathy for your position, but I guess I don't understand exactly what the logical conclusion of that is, because are you saying that a juvenile court judge in this circumstance must actually detail the factual findings as opposed to saying I adopt what the magistrate concluded?
So the juvenile court judge certainly could say that they adopted what the magistrate concluded, or include some recitation of the facts based on what the judge determines, or reiterating what came from the magistrate, but that didn't happen here. There was no specific reference to those facts being properly determined by the magistrate.
So you're saying that the trial court here did not say I adopt those findings as my own?
Correct. So that was what was missing and what needed to occur to determine that those factual findings were accurate. As to the second assignment of error, the adjudication for obstruction was against both the sufficiency and manifest weight of the evidence. Now, as to the different elements, as to the Affirmative Act, the complaint here in this case was that RB fled from a vacant house, although the court later looked at the fact that they determined that RB ran and RB closed the door. But Officer Heron couldn't see anyone inside the door, nor did his body-worn camera pick up the sound of anyone running inside the house, although he testified to hearing someone running.
Didn't RB admit? I thought he said something like he shut the door because he thought there was another juvenile coming in.
So RB didn't say that he shut the door because he thought another juvenile was coming in. RB was in the house and hid because he thought some other juvenile was outside.
Okay.
But even if RB did close the door and did move away from the door, those would be akin to failing to identify oneself to police. And even if this court were to look at either of those being an affirmative act, we have to look at whether or not RB was under any duty to comply with the officers. And in this case, it was not until Officer Herring kicked open the door that he announced his presence as police, where anybody in the house could hear that being announced. And so immediately at that point, that's when RB announced his presence and came forward in front of the door.
Did the officer testify that he heard the door click?
The officer testified to a sound of moving in the wind, and seeing the door closed. The door is only open a crack.
Yeah, I mean, it's just very difficult from the video to tell whether the door actually closes all the way or not.
Sure.
And so I just can't recall his testimony. Did he explain that it closed all the way? Was that his perception?
Well, initially on direct examination, his perception was that the door was slammed in his face. And then on cross-examination, he acknowledged that no, it didn't slam in his face, that his testimony was that it closed. But
did the magistrate judge make a finding that Arby knew that the police were trying to get into the house?
Yes,
And if so, is what evidence in the record is there or lack of?
yes, so the magistrate did determine that Arby had to know that it was officers because the door closed, or whether it shut or partially closed further, right when officers were approaching. But what was missing was you don't see, somebody's face peeking out from behind the door or at a window. Somebody may hear the sound of somebody outside, not know who it is, or see that in this case that it was officers. Even if RV did close the door, we don't know that also wasn't wind at that point in time, but with Officer Herring's description of moving in the wind.
Well, there's no evidence that that RB perceived there to be police officers outside, is there? Because as I recall from the video, the door had no windows on it, and it was only cracked, seemingly like an inch or a very small amount, and there were no windows in that room that would look out. So it's certainly possible that he wasn't able to see who was out there. So I was just curious if there contrary evidence that would indicate that he actually perceived there to be police officers outside.
No, there wasn't any, and he even acknowledged, thinking that it was, when he heard noise, that it was other juveniles. And the police officers initially arrived at the scene without lights or sirens, and so there would have been no indication to him, without him again, poking his head around the door to see that it was actually officers, to know it was officers. But this case would be akin to State v. Crawford out of the 2nd District, where that case, that the defendant in that case actually saw that police were approaching and alerted other people to the presence of those officers. And before there was any command to do anything, that person alerted the other people in the house to the presence of police, closed the door while the individual stayed inside. And that's what happened here. At the point where there was an identification of police being present, that's when RB immediately identified himself. But before that time, he wasn't under any duty to comply with the officers or to do anything. And so even if he shut the door, even if he ran, all of that would have occurred before Officer Herring announced himself or issued any command to RB. It wasn't as if, upon approaching the door, officers announced themselves as police and said, "Keep the door open." And here, the actions were not for the purpose of preventing or obstructing or delaying the police. When you look at RB's overall course of conduct, it's clear, again, once police announced their presence, he identified himself, he was cooperative, and he was taken into custody within a very short time of all of this happening. And the magistrate even acknowledges in her decision that, this does occur within a short period of time. This isn't a situation where, RB was resisting or doing something else at the point where the officers identified themselves. And RB did not actually hamper or impede the officers. So here, the magistrate based the obstruction on the officers having to draw his weapon, kick open the door, order another officer to go to the front of the house, and threaten to release a dog. But none of those actually hampered the police officers, because this is the exact call that the officers were ordered to do. This isn't a situation where RB allegedly ran down the street to another house, not the house that the officers were called to investigate. That was the house that they were going. Their job was to ascertain whether people were in the house and to secure the house. And that was whether or not a door was open. And so really, determining whether people in the house occurred probably sooner than it would have otherwise. Officer Herring and the other officer would have certainly then gone into the house to determine if other individuals were there. It seems unreasonable they wouldn't have their weapons drawn to look at a house if they were being called to search a vacant house. And so all of these things did not hamper the officers, because they would have done all of them anyway. This is what.
But you're saying that they would have had their weapons drawn anyway if they were just looking in the house and didn't think there was anyone in there?
Well, the call was for people in a vacant house. So I don't think it's unreasonable that the officers would have had weapons drawn to go in there and search the house. But even if drawing weapons, that was, again, what they were called to investigate. Here, if this court were to uphold the adjudication, it would essentially give police the ability to charge any person with a crime for if they're arrested at the scene where the officers were called to investigate. So here, once you have the announcement of identification of the police and RB cooperating, the fact that the police had to then ask if anybody was in the house or take any action, that certainly should not have led to an obstruction of official business charge. Additionally, if there was any delay, it certainly was de minimis, as discussed in Crawford, because it was just a matter of a second or two of when this was happening. If there are no other questions, then I would reserve the remainder of my time.
Okay, thank you, Ms. Moss. Ms. Steer?
Thank you, Your Honor. Good morning. May it please the court. If I can just pick up where Ms. Moss left off as far as Crawford, I think the difference between this case and Crawford is that the police duty that they were doing in Crawford was executing a warrant. They weren't delayed in executing the warrant. They were able to complete their search. Here, the duty that our police officers were supposed to be doing was checking out a vacant house. When the door shut in Officer Herring's face and then he heard someone running away, he had to draw his weapon and call for backup.
Well, I guess that's what I want to understand, because in terms of the actually hampering or impeding the officer, like, it was a vacant house. Presumably he would have gone in any way to confirm that there was no one in there. And the fact that the door closed, if it did, that didn't stop him. It wasn't locked. It would be a more compelling argument if it were locked. He immediately entered the house. So I mean, we're talking about a matter of seconds before the juvenile identifies himself. So I'm trying to understand, what is the actual impeding or hampering that is taking place here?
I do agree that it's a small hampering, but the statute does say the statute does say hamper. It's not preventing him from doing it, just hampering. So I think that does kind of encompass a small delay. And I think that it's not just the door shutting when the officer was approaching, but I think it's also hearing someone run away. So it wasn't just that the door was shut and that he had to open a door. It was that there's someone who ran away and he had to stand in there with his weapon drawn and call for backup. But
part of the problem here is that the juvenile was completely compliant with the officer's demand. And I guess I'm concerned about, like, what would be the repercussion if we say, hey, if you're completely compliant, you still get arrested for obstruction?
Well, he's running in a place where he has no privilege to be. I think it's different if you were somewhere where you had privilege to be, but when he's trespassing in a house and running away from an officer, and the magistrate found that the juvenile knew that it was a police officer approaching the door. So
let me, and I'm sorry to keep interrupting you, but
that's okay.
Let me ask you about that finding, because going back to my question to Ms. Moss, like, as I watched the video, it's quite conceivable that the juvenile could not perceive there to be police officers. So what is the evidence, the best evidence to support the finding that he understood they were police officers?
I think the fact that that Officer Herring was in his uniform in the middle of the day, or well, it was 6 o'clock in July, so it was still light out. There was a police cruiser there. Prior to Officer Herring approaching the door, they were walking around the house. I think actually they yelled police while they were in the garage, because they checked out. It looked like a vacant garage behind the house. So I think that it's reasonable to think that the juvenile knew that there were police officers approaching. I know that he said he thought.
Ms. Steer, let me ask you a question. Doesn't the case law say that there has to be a substantial impairment? And just to follow up on Judge Bergeron's question, when the door closes, by whatever means, the officer almost instantaneously kicks it open. and nobody's there. He did testify here running, but that person would have had to been really fast because he kicks it open. It's a fairly large room and there's nobody there.
Right.
So my question is, how was he, the officer, substantially impaired?
I think he was impaired from the time he approached the door and the door shut, and at the time he had to stand in the room. I think that stopped his ability to clear the house because he knew someone was in there at that point, someone who had run away at his approach. And I think that impaired him. I agree that I think these are, it's a fairly close call. I think it's sufficient. There's sufficient evidence of obstruction. And I think that the magistrate found that the weight of the evidence, it was not against the weight of the evidence.
But with regard to the intent, your argument is that he had to know that the police were there because it was broad daylight, and we can assume that he either saw them or heard them yell police into the back garage.
Right. That's what the magistrate found, was that he knew that he would have known that there was a police officer at the door when he approached. If I could just touch quickly on the first assignment of error, there's nothing in Juvenile Rule 40 that requires that the trial court list findings. The trial court adopted the magistrate's decision. The decision included all of her findings. So I think by adopting the decision, he adopted her findings. And unless there's anything else, I'll rest on my brief. Thank you.
Okay. Thank you. Ms. Walsh, you have your rebuttal.
Yes, right. And this court certainly has watched the video, but even when officers are in that back shed area, when they announce themselves as officers at that point, that wouldn't have been something where somebody in the house would have been able to hear it. That was pretty quiet, and there was a distance between the shed and the house. But as to Officer Herring having to call for backup, even though he did call for backup, he didn't wait for backup to arrive. So even that can't be a basis for any stoppage of Officer Herring's actions. And just, Mr. and I have different opinion on the interpretation of Crawford, but just like Crawford, even though they were executing a search warrant, here it would be the same, since they were going to determine whether or not anyone was vacant in the house. If, let's say, they showed up and the door was closed to begin with, they still likely would have done what they were called to do, was determine whether or not anyone was in that house. And so for that reason, all of the elements would not have been met as to the obstruction of official business. And we would ask that this court reverse the juvenile court's decision. Thank you.
Okay, thank you both for your arguments this morning. We appreciate it. The case will be submitted and we'll issue a timely written decision. Hope you both have a great day.
Thanks, you too.
Good morning. Welcome to the First District Court of Appeals. Our second case to be argued this morning is Williams versus City of Cincinnati. Ms. Barron, how much time would you like for rebuttal this morning?
I'd like to reserve 3 minutes, please. 3
minutes. Okay, your volume is a little bit low. I don't know if you can maybe get a little bit closer to the mic.
Let me see if I can shift the table a little bit more. Did that help at all?
It did, yes. Okay. Thank you.
Good.
You may proceed when you're ready.
All right. May it please the court. My name is Catherine Barron, and I represent the appellant in this case, the City of Cincinnati. This appeal stems from the trial court's incorrect determination that the city was not entitled to governmental immunity when Ms. Williams, the appellee, tripped and fell on a sidewalk. The city respectfully requests that this court reverse the trial court's decision for 3 reasons. First, the clear statutory language of Revised Code Section 2744 indicates that the city is entitled to immunity in these types of cases. Second, the legislative history of the statute also indicates that the General Assembly intended for the city to maintain immunity for trips and falls on sidewalks. And finally, the precedent set in this court in Evans versus City of Cincinnati also indicates that the city is entitled to immunity when individuals fall on sidewalks. For these reasons, the city respectfully requests that this court reverse the trial court's decision. First, the clear statutory language of Revised Code Section 2744 indicates that the city is immune from liability in these types of cases. As this court is well aware, to determine whether a municipality is entitled to immunity, courts employ a three-tier analysis. In the first tier, political subdivisions are generally not liable for injuries in connection with governmental or proprietary functions. In this case, if you look to the statute, it specifically lists sidewalk repairs and sidewalk maintenance as governmental functions. Therefore, under the first tier, the city is entitled to immunity. The court then moves to the second tier to determine whether any of the exceptions to immunity apply. In this case, the city contends that none of the exceptions apply. These exceptions—
And this was decided on a motion for judgment on the pleadings, correct?
That is correct.
And so I guess my question is, as we're deciding like whether these exceptions exist or apply, is it appropriate to do that on a judgment for the pleadings versus summary judgment where there's a more fully developed factual record?
I think that the court should look at what's in the complaint. The complaint never, and the pleadings that have been part of the record for that matter. And there is nothing in the complaints or in any of the pleadings to indicate that any of the exceptions would apply. Specifically, they plead that this incident occurred on the sidewalk. There's no, I know in their brief, they indicate the roadway exception may apply here. However, there's never been any indication that this incident occurred on the roadway. So I think it's clear from the pleadings as well as the complaint, none of the exceptions apply. It's also common sense that an individual wouldn't be able to fall on a sidewalk and also fall on the roadway as well. So I think they're very clear in their pleadings that this occurred on a sidewalk rather than in the roadway. Some of the other exceptions to immunity here are injuries caused by negligent operation of motor vehicle. We don't have any indication of that in the complaint. Negligent performance of proprietary functions. As previously discussed, this is very clearly a governmental function by statute. Injuries caused by failure to keep roads, highways, and streets open and repair. As previously discussed, the complaint very well pleads that this happened on a sidewalk, not in a roadway. Injuries caused by negligence on the grounds of buildings used for governmental purposes. We don't have that here. And injuries for which liability is expressly imposed. So for these reasons, the city contends that none of the exceptions to immunity apply. And because none of the exceptions to immunity apply, this court need not engage in the third tier of analysis, and the city is clearly entitled to immunity by the clear language of the statute. If the court's unconvinced by the clear language of the statute, it can look to the legislative history of the statute, which also indicates that the General Assembly intended for the city to maintain its immunity for injuries occurring on the sidewalk. Specifically, prior to 2003, when they amended this statute, it previously read, political subdivisions are liable for injuries, death, or loss of person or property caused by, among other things, their failure to keep sidewalks free from nuisance. In 2003, when the General Assembly amended this section, they removed sidewalks as an exception to immunity. And based on that, you can see from their clear intent that they intended the city to be immune for sidewalks. If they had wanted an exception for immunity on sidewalk injuries, they would have left that language in the statute, and instead they removed it in the amendment in 2003. And finally, the precedent set in this case, in this court, specifically shows also that the city is entitled to immunity here. In Evans versus City of Cincinnati, the court found that the city was immune from liability when a person tripped and fell over an obstruction on the sidewalk. Specifically, in that case, the plaintiff's pant leg became caught on a broken metal sign pole that was jutting from the sidewalk. The court noted that sidewalk maintenance is a governmental function, and after engaging in the aforementioned three-part analysis, the city was immune from liability. Here, Ms. Williams similarly alleges that she tripped over a broken signpost that was located on the sidewalk. And as there are no principal distinctions between this case and Evans, this court should find that the city is also immune from liability. In conclusion, based on the statutory language of Chapter 2744, the legislative history of this statute, and precedent from this court, the city is clearly immune from liability here. As such, the city respectfully requests that this court reverse the trial court's decision. And I'll submit.
Thank you. Mr. Eisenmore.
Good morning, ladies and gentlemen of the court. Thank you, Ms. Barron, as well. This is my first time in front of the Court of Appeals, so if you don't mind,
You're welcome.
Thank you. I appreciate that. I'll just jump right into the case. I'm sorry I can't be there in person. Good morning, members of the court. My name is Tobias Eisenmore. I'm a counsel for plaintiff appellant Norma Williams. We're here on the city's appeal from the properly decided motion for summary judgment on the pleadings. I'm going to be asking this court to uphold the circuit court's properly founded decision. Just a little bit of background on the case. Sometime in 2017, the city caused a sign to be removed from the public right-of-way on the corner of Broadway and 8th Street. It's a very busy intersection right near the courthouse. The city failed to properly remove this sign, and instead they left a short, jagged piece of metal sticking up out of the sidewalk just a little bit. Not something you would see very clearly, but definitely something that you could easily trip over. It was just a matter of.
But I think part of the problem is, this is almost exactly on all fours with Evans and our prior precedent on problems with sidewalks. And I realize you all are trying to kind of get around that by using the roadway exception, but I have difficulty conceptually understanding how a sidewalk can be both a sidewalk and a public road.
Yes, sir. I'm happy to address that. I think when you look at the Evans case, so much of that case came down to argument over the governmental versus proprietary function there. And the Evanses tried to backdoor this in as a proprietary function of the government by saying it was negligent maintenance of a sign, which would fall under proprietary. And the court ultimately was convinced that this was part of the roadway maintenance governmental function and ruled against the Evanses. But in this case, we're not contending that this was a proprietary function. It's maintenance of the roadways is covered as governmental functions. However, there are several exceptions to immunity for governmental functions. And Ms. Barron
before you get into that, did you, in your complaint, did you say this was a roadway or a sidewalk?
It's a sidewalk, Your Honor.
Okay.
And I believe that the exception there, Ms. Barron says, is it's clear from the legislative intent that sidewalks were meant to be removed from that. But I don't think the legislation, I don't think it's that clear, honestly. I think when you look at what the amendment was in 2003, they didn't just go in and delete the phrase sidewalks. They cleaned up the entire piece of the entire statute there to replace it with roads. And they put a reference to the definitions of roads that said, here's what counts as roads, and here's what doesn't count as roads. And what didn't count as roads, they had a specific list of things stating that they did not count bridges, traffic control devices, berms, and shoulders. So if they were specifically intending to remove sidewalks from this public roads exception, they would have put it into that list of things specifically excluded from what counts as a public road. There's a list right there in the statute. So I don't think it's actually clear from the face that they meant to remove sidewalks from this public road exception. And diving deeper into what the legislative intent there is, what is the purpose of the sovereign immunity doctrine? To protect the city from these things. Why, if someone tripped over a signpost or a jagged piece of metal left up by the U-Scans and Kroger, there would be no question about it. Kroger would be liable for that. But at a certain point, sovereign immunity is called on to protect the city in certain cases. So we have to ask ourselves, why does this doctrine exist? I'm not here to argue that sovereign immunity shouldn't exist, but I think when you want to talk about legislative history and case law here, it's clear that sovereign immunity is meant to protect police functions and discretionary governmental functions to help the government continue to function. We don't want to be second guessing every action that the government takes. We don't want police officers to be concerned that they're going to be sued for performance of their duty, performance in the line of duty. The sovereign.
Well, but I think, I mean, look, we could have certainly an interesting debate about the normative justification of sovereign immunity, but it's also a maintenance issue. And like, I think about the sidewalks in my neighborhood, and there's not jagged signs pointing up, but there are a lot of uneven sidewalks. And when I run over those early in the morning, it's dark, like I could trip and I have tripped and fallen and hurt myself. Fortunately, not seriously, but I think like if every single imperfection of the sidewalk is a basis for a lawsuit, I mean, that could quickly bankrupt the city. So it's not just the police functions, it's also kind of the maintenance functions, right?
Yes, sir. And I'd be happy to speak to that as well. I think when you look at the maintenance overall of the sidewalks, of course, there's going to be many situations where there's just so many miles of sidewalk in the city. It's not possible to expect a city government to be able to maintain every inch of sidewalk, perfectly flat and smooth. And I used to work for a city government, and I had to defend sovereign immunity claims for our city's dredging policies. This is when I worked for the city of Virginia Beach, and people would sue the city because their yards would be flooded or because their channels would be non-navigable due to the city's dredging cycle for the channels there. And that was all protected under sovereign immunity because it was discretionary how that maintenance was done. But in this case, we're talking about specifically this signpost was removed negligently. It was left in a manner that was very dangerous and causing a huge risk of injury, which did in fact happen, which is another reason why I think that a motion for judgment on the pleadings here is not appropriate, because I think the facts of this case, there's still many factual issues in dispute here. But I think this case in particular, it's not about saying the city is responsible for anything that happens on the sidewalk. It's saying, look, in this case, the city left a very dangerous instrumentality there that posed a huge risk and caused someone to be very seriously injured. It's not just that they couldn't get around to fixing a crack in the sidewalk. It's that the job that they did in a way that created danger. There's a lot of facts here that need to be decided by a trier of fact and not just thrown out under a sovereign immunity claim. So I think that the specific way that this was done shows how much this needs to be actually heard by a jury instead of just being ruled on as a sovereign immunity claim. I agree that the public roads exception is not very clear. When you look at the statutes, obviously maintenance of roads and sidewalks are listed as governmental functions, and they're put that way directly in the statute. But then the exceptions to that, trying to define the intent of how these are put together is not very clear, because they don't include sidewalks, but they also don't specifically exclude sidewalks. And I think when you look at the other exceptions to sovereign immunity, one of them is negligent maintenance of public grounds, such as a courthouse. So if the city left a jagged signpost sticking up in the middle of the courthouse floor and someone tripped over that, the city would be liable for that. Same, I believe, with if they left something sticking up out of the road, a dangerous instrumentality in the road, the city is liable for that. And I believe it should apply to the sidewalks as well. I don't think that there's anything clear that states whether sidewalks should be encompassed by the public roads exception, but I think based on, if we talk about legislative intent, I think it should be. I think it should be construed that way, especially because the city had the opportunity when they wrote this statute. The state, when they wrote this statute, and they listed out the things that do not count as public roads there, they could have put sidewalks right in there, and they did not do that. So I think it's not clear that they were trying to carve out this safe harbor for sidewalks. And then when you talk about the meaning of sovereign immunity, why should the sidewalks be a separate entity other than roads and avenues and other publicly maintained facilities. You know, what would be the purpose of excluding negligence or sidewalks in that? It's not really clear what the purpose is. The only thing that is specifically excluded would be, the bridges and the traffic control devices, which I believe in Evans was the way that they tried to get around this governmental immunity claim, which is by saying maintenance of traffic control devices is a proprietary function. And this court wasn't convinced on that, but that's not the type of argument that we're here to make. We're here to say, even if this is a governmental function, the exceptions to immunity would clearly apply here. Sorry, I got a little bit off track there when I was answering questions. I got to be ready for that. I had my whole argument listed out here, so if you wouldn't mind, I just want to give this a look to make sure I covered everything that I thought I needed to bring up today.
Sure.
I just wanted to point out that there are several cases on point decrying this proprietary versus governmental exception system here. The Ohio Supreme Court said that there are absurd consequences that result from attempting to distinguish proprietary and governmental functions in determining whether a municipality is amenable to suit. Overall,
didn't that predate the promulgation of the statute?
Did Strohofer predate that? I don't have the actual date in front of me, but I think that overall, the doctrine of sovereign immunity is not favored. Just like a motion for judgment on the pleadings or any dispositive motion like that is not favored. So I think the city is in a kind of a double bind there, where they're here on a dispositive motion asking for sovereign immunity to apply in a case, and both of those things should be looked on strongly with disfavor by this court. Sovereign immunity is supposed to be, that's why they've carved out so many exceptions to the doctrine of sovereign immunity, because it's something that the courts have started to look on with disfavor. I can find these statutes here, but I do believe that the city is here kind of on a dispositive motion, asking for something to be done under sovereign immunity, and both of those things have an extremely high bar to being granted. So that's why I think that it's just not an appropriate time to try and bring the sovereign immunity claim. There's clearly many material facts in dispute here. The city issued a blanket denial of all the claims. So they issued a denial stating that they're responsible for maintaining the sidewalk. They denied that Ms. Williams was injured. They denied that they did the maintenance in question here. There's a lot up in the air still that hasn't been decided. There are factual issues that are still in dispute. So asking for this to be decided here on a motion for judgment on the pleadings, I think is premature.
Okay. Anything else, Mr. Eisenlohr?
No, Your Honor, I believe I covered everything I wanted to discuss, so I'll rest now. Thank you.
Okay, thank you. Ms. Barron, you have rebuttal.
Thank you. So one of the big things that the appellee in this case has been arguing is that this is not the appropriate time for the court to determine whether or not the city is entitled to immunity. However, this is the prime time for the courts to determine whether the city is entitled to immunity, because one of the purposes of immunity is an early determination to conserve fiscal resources of political subdivisions by limiting their cost of defense and exposure to damages. So this is the time that is contemplated for these types of decisions. So while appellee may argue that there are still material facts in issue, what the city is arguing is that what is pled in the complaint clearly shows that the city is not liable for any of these damages, and that the case should be dismissed before any major expenses are incurred by taxpayers.
So even though you denied the basic allegations that it occurred on a sidewalk and the city was responsible for the maintenance of the sidewalk, you would say that you would agree, for purposes of resolution of this motion, to accept their facts as true. Is that what you're saying?
That's correct. That's exactly correct. And I think that that's the burden that is placed in a motion for judgment of the pleadings, that all of the facts that are in the complaint are accepted as true, unless they're obviously not supported. But we're not arguing that here. So based off of that, I think this is the appropriate time for these types of decisions to be made. Moreover, I know that there was a lot of discussion about the legislative intent. I would just ask that the court look to the clear language. It's not ambiguous here. Sidewalks are not kind of mentioned and kind of not. They're clearly not there as an exception to immunity. And even if the court is persuaded by the appellee's argument there, if you look at the clear language of the statute, this is a governmental function and the city's clearly entitled to immunity. Moreover, as the court, I think, indicated, this case is on point with the precedent that was set in Evans versus City of Cincinnati, and there have been no principal distinctions made by the appellee. So for these reasons, we are asking that the court reverse the trial court's decision.
Okay, thank you both for your arguments this morning. We appreciate it. The case will be submitted and we'll issue a timely written decision, and hope you both have a great day.
Thank you, Your Honor.
Thank you.
Thank you, Judge. Thank you, Ms. Barron.
Thanks.